Jadine, in your opinion, what should an employee that's just been dismissed never do?
I think it's important for employees to take note that there may still be a formal process to follow. So that's the CCMA if you are going to refer your matter. So you need to be very careful of taking it to social media and trying to slander the employer's name, trying to drag other employees under the bus. And that would be if you post on a WhatsApp status, if you post on Facebook or Instagram or TikTok or any of the social media platforms. I think that could also detrimentally affect your outcome at the CCMA. I mean, if the employer decides to use that to show your character or to show, how you were as an employee at the workplace, if this is how you behave. I think an employer can, from their side, also take civil action against you, dependent on what you've posted on social media and how you've, what you've said about the company and the employees at the company.
Fight your fight at the correct forum.
Correct.
At the correct platform. Don't go to social media. There is a platform. It's sanctioned. It's called the CCMA. There is a commissioner who's going to listen to your case. Fight your fight in the correct platform. I think that's the key takeaway.
Are the crux of it.
One of the most common mistakes I see employers make when dismissing employees is the process.
Yes.
It's botched. They don't follow the correct procedure. Then they get emotional and then they dismiss an employee for a transgression that's actually not a dismissible offense.
Yeah. I mean, oftentimes I refer to the example of an American movie where the boss walks into the office and immediately yells to someone, "You're fired." And I mean, if we consider that in South Africa's labor law, it's not a fair procedure. So we understand that at that point in time, emotions and tensions are high, and the employer then needs to take a step back, seek guidance if it's necessary, and deal with the matter efficiently in terms of the process. Issue the employee the notice to attend, hold the hearing, and only if it is a fair outcome, dismiss the employee.
The problem is employers' framework is Hollywood, and that's not a good framework.
That's true.
It's not The Apprentice, it's not Suits. You can't just dismiss employees. Unfortunately, a process needs to supersede the dismissal.
Yes. Christy, what would you say the benefit is to an individual of seeking early legal advice and guidance instead of dealing with the matter themselves?
Well, Jadina, a lot of employers try that and then only later on consults with us. And the problem with that is employers pay a lot of school fees. They try to go it themselves, they look at the legal fees and they say, wait a minute, I can do this myself. ChatGTP, that doesn't end well.
No.
So then they come to us, then we do damage control. So I would say, don't look at the legal costs, appoint a specialist. The cost is going to be vastly more if you lose the case than what you will pay for your legal advisor. So get legal advice, do it the right way. That would be my advice. Jadine, can you think of any examples where a client did not seek legal advice early, and what was the outcome?
When a client waits, whether it's an employer or an employee, waits to seek legal advice, the matter can be delayed unnecessarily. Things can go very wrong at the CCMA. I mean, you can get an award that is just not in your favor, and that could have been prevented. Most recently, a situation that I've dealt with was where an applicant, so an employee party, had attempted to take a matter, incredibly complex matter on at the CCMA on his own. And this had resulted in a 6-month process where the matter was set down for arbitration and had been constantly and continuously postponed because the employee or the applicant just didn't understand the process that needed to take place. So getting that advice early assists the employee in getting the ball rolling, getting speedy and expeditious resolutions to their disputes, which is what the CCMA is. It's a forum of speedy and expeditious resolution for unfair dismissal disputes.
Just to add to that, I think we always advise our clients that you have one chance at this.
Yes.
You've been unfairly dismissed. This is your chance to win or lose your case. You can do it yourself, or you can try, or you can get expert advice and give it the best possible chance that you have. If you lose, you lose. That's the risk factor here. So if you consider what's at risk, it's either your livelihood, reinstatement. There's a lot of things at risk here. So do it the right way, get legal advice.
Especially in employee circumstances, I think they often don't realize what effect an unfair dismissal will have on their chances for prospective employment moving forward. Christo, can you think of any small mistake that an employer has made in the beginning of a case or beginning of an unfair dismissal that ultimately snowballed and ended up in a very big problem at the end of an unfair dismissal case?
I have a lot of examples, but let me pick one. We have a client. He, being an employer, formulated charges. The employee, they alleged, had been guilty of insubordination. Charges were formulated to say, you are guilty of insubordination. You did not follow our instruction. You failed to follow our instruction and to submit a certain project. Now we get to the CCMA. If your charges are not formulated correctly, to say which project, which project did the employee not submit? Was it 1, 2, 3, 4, 5? When? How? How was the instruction formulated? The charge was very vague. With a vague charge, things progressed through the CCMA. Ultimately, the employee was successful. The employer lost the case. Then the employer consulted with us. Matter was taken on review. But that is an example of where small mistakes can creep in and then become big mistakes.
Which is why it's so important to, from the beginning of a matter, seek advice from a professional and get their opinions, get their input from the beginning to avoid any small problems becoming bigger problems later. Christo, what is the biggest misconception that employers, so companies and businesses, have about an employee's probation period?
Jadine, I get a lot of clients sitting across from me in the boardroom. And when I explain this to them, it seems foreign, but a lot of my clients think that when an employee is in a probation period and you are not happy with this employee, you can simply terminate.
Yes.
And say, look, we've tried this. It's within your probation period. That's the end. Give a notice and there you go. And that is a big misconception and a mistake that our clients make. Firstly, the only thing that the Labour Relations Act says about probation is you need less compelling reasons to dismiss.
Correct.
However, but you still need to follow a process. There still needs to be a performance process, a disciplinary process before you can terminate. I think that is one of the biggest mistakes I see my clients make.
I think a lot of employers also don't grasp the weight of responsibility on their shoulders when they do take on a new employee during a probation period. It's important for them to know that they need to sufficiently train this employee, conduct onboarding, conduct training, document the training, ensure that the employee signs off on that, ensure that the employee has sufficient knowledge and training to do their actual scope of work, to attend to their responsibilities and duties. And if that doesn't happen within those first 3 months and a dismissal takes place, the chances of the employee winning an unfair dismissal case at the CCMA is much higher than what it was had you followed the correct training processes and procedures.
Jadine, to add to that, I would advise employers to note probation is not a fixed term contract.
Yes.
Most of my clients think, well, I've given an employer a contract, they've signed it, there's a probation period of 3 months. It's a fixed term period. So when that fixed term comes to an end, I can decide, do I want to continue with the relationship?
Yeah.
No, don't think that. It's a permanent relationship.
Correct.
This 3 months is just to consider how the employer is performing. However, you can't just terminate. The relationship and the termination must be preceded by a disciplinary process. Keep that in mind.
A lot of employers also would rather provide a fixed term contract for 3 months. Call it a fixed term contract, call it a probation contract. And then it's almost like you've just explained. They've tried to get away with seeing whether or not this employee fits in. And that's where this incompatibility dismissal comes in. Rather to follow that route than through a fixed term contract or a probation contract. So, Christo, when an employer is looking at dismissing an employee during the probation period, what are some of the key things that they should focus on?
Firstly, the probation period is not a fixed term contract. you need to follow a process before terminating.
Yes.
You can't just give notice at the end of the 3 months. So if you find within the 3 months of assessment this employer is not smoking the pipe, you've tried, you need to follow a process, a performance process. One, you need to inform the employee what is expected of them. Preferably in writing. Do not just communicate this verbally, put it in writing. If you did not know, now you know. This is what we expect of you. These are your performance targets. Give the employee time to meet those targets, fair time, set period. Okay, we are giving you 2 weeks to meet these targets. After the 2 weeks, have a consultation. Take stock. Did they meet the target or not? If not, continue and repeat the process at least 2, 3, 4 times before the 3 months probation is over. If you find that there is still hope, then you can extend that probation period for an additional period within reason and follow that same process. However, if you ultimately find as an employer that the employee is not fit for purpose, then you must follow still an incapacity hearing before dismissal. So those are the key takeaways. We see a lot of clients that are unaware of this requirement.
Yeah. Chris, I'd like to just give you an example as well and get your advice on that for when it may be fair to dismiss an employee during a probation period. So if a company then employs an employee and within the first month of that employee's employment, he's been late on maybe, let's say, twice a week, 3 times a week, what would that more or less look like in terms of what process would follow? Would it be fair? And what would the outcome ultimately be?
Okay. Key takeaway is the act is clear. If an employee is within their probation period, you need less compelling reasons to dismiss. Meaning, the misconduct does not need to be that serious. Now, there's no, they do not specify which misconduct, but that is the guideline. So if an employer finds that an employee contravenes the code or contravenes a rule or standard, they may dismiss this employee for less compelling reasons. So the threshold is lower, and that's something employers must consider.